is Debra Oppenheimer, and I'm going to be your presenter today. If you're not familiar with me, I've been with Altitude Community Law for 17 years and counting, and I've been doing covenant enforcement the whole time. So hopefully we'll touch upon things, but feel free to ask questions if you have. You should be able to type them into the questions area. On the screen, you should see the PowerPoint in the center of your screen, and that should take up most of your screen. And then there should be a small box at the bottom with a video feed of myself. Sorry about that. On the left side, there is the menu. You should see a questions and answers icon where you can type any of your questions that you have. And CMCA credits will be generated once the webinar is provided with an attendance confirmation report from the website. And then you will get your credits sent to you via email within 48 hours after the webinar. The credits are non-transferable. If you have any questions, any concerns, just go ahead and email education@altitude.law or call Sean directly if you have any questions or don't receive your CMCA credits and certificates. Okay, so what are we covering today? We're going to try and cover and talk about some of the things that we're seeing with judges, what they're doing, what they're having pop up in the courtroom. Some of the things have been changed and caused by COVID. Some of them are just changes due to timing and just evolution of the courts and the judges. So they made it fancy. So the courts have changed since COVID. As many of you have seen, if you had any courtroom cases or anything pop up during the period of time that COVID was happening, you would have noticed that you weren't going to court. You were going to link in via WebEx or via Zoom, but you didn't go into the courtroom. And the courts like that. They've decided that, they can save a lot of time, yours, theirs, everybody's, by not making people drive to the courthouse. There's less people who show up late because they couldn't find parking or couldn't get through security. And so now they have options they never had before. They don't have the hearing via in person. It can be virtual. And if they do have the hearing in person, then the issue becomes whether or not you have to wear a mask or not. And I will tell you that that is something that judges hate. Attorneys don't like it either, simply because when you are looking at somebody and talking to somebody and you're trying to judge credibility, which is the job of a judge or a jury, it's hard to do that when you can't see their whole face. And so getting rid of the masks is something that a lot of courts are doing. I still see it. I still see some of the courtrooms have it, but a huge chunk of the courtrooms are doing away with the mask. They're just not even having it. And so that makes it really convenient. What most of the courts have done with this to this point is they have made each hearing kind of a hit or miss for whether or not it's going to be in person. And so if you have court cases, if you're working on a file, whether it's collections, covenants, your HOA is being sued, you always need to reach out to your attorney. Is this in person? Is this via a WebEx? Now, remember the other thing, that just because it is via WebEx, your attorney may want you in the same room with them because it makes it easier to talk to you about what you're going to provide, what you're going to present. But you need to talk through, maybe you're not going to be in person, but you're going to be via WebEx, but at the attorney's office. So you and the attorney are side by side presenting what you're going to present. Because the courts were shut down for so long, they're buried. In the past, civil cases generally had their own divisions, and while it took a while to get trials and get a date set, you got them, right? You eventually got a date that could work out with your attorney and the opposing counsel and get it set. You generally did not go beyond 6 months to get a trial date in county court. You did not go beyond 2 years in district court. Now it's completely a new ballgame because the criminal cases got backed up, they have priority. And because there are so many trials that need to go, the courts have called in senior judges. So it is not uncommon to have somebody who has been retired off the bench but coming back in as a senior judge to help things out. Depending how long he's been off the bench, he may not be familiar with new laws. He may not know what's going on. So you may have to educate him more than you would. It may be a benefit. I had a case last week where a senior judge stepped in on a temporary injunction request. And he was a very experienced judge. And instead of having to educate him, you could just give him basically the nitty-gritty. It was very quick because he understood and had so much experience. So sometimes it works in your favor. Other times, a senior judge, it's very difficult. So you have to understand there may be more prep work that needs to happen. And you have to be ready to know that your case is going to take a long time. Some of the courts, when we're setting for a trial, create a priority list, and you can see you're matched up there with a bunch of criminal cases. And if any of those criminal cases are ready to go to trial, you're going to be bounced. You are going to be delayed down the road because the criminal cases are going to take priority over the civil case. Mediation has also changed. Mediators across the board are all utilizing virtual mediation. And so this is something that can be a benefit. It's easier to get together, doesn't matter where you're at. And it's easier to grab board members because they don't have to take off from work. They can just take a break and join into the mediation. And so the mediations are now being virtual. Again, sometimes that's good, sometimes that's not so good. The good mediators out there have the ability to put everybody in what they call a room and separate the plaintiffs in one room, defendants in another room. So you can have conversations, the board and the attorney, and make sure you're all discussing the case together with outside of the hearing of the opposing party and the opposing attorney. As attorneys, we're getting lists, so we know which mediators can do this and who can utilize the ability to have separate rooms, but not all of them. There's some very good mediators out there that have not learned the technology. And while they're awesome mediators in person, because they haven't learned the technology, they don't have the ability to separate you into groups. You don't have the ability to talk to each other. So when you're talking about mediation and mediators, the discussions are quite different than they used to be in the past. Instead of just, do we like this mediator? Does he understand HOA work? Now we're talking, does he get HOAs and does he get technology so that we can all work well together? And it may be that if in fact you have a great mediator, but he doesn't do well with technology, again, you may want to everybody meet at the attorney's office so that you're in the same room. And so when the mediator calls you up, even if he puts you on hold to go talk to the defendant, you're with your attorney and you can all talk together. But different discussions have to be made, different ideas have to be discussed because of how this is all happening now. Judges and magistrates. I bring this up because with the courts being busy as they are, it's important to understand kind of some of the things happening with the judges. First, there is not a lot of difference between judges and magistrates other than a Colorado magistrate is appointed by the senior judge in the county. So if you're in Denver County, the senior judge would interview and appoint a magistrate in Denver County. And a magistrate can handle most things that a judge can handle, but they work under the supervision of the senior judge or the Article 6 judge, which is a judge who is appointed by the governor. Okay. Parties can object to being in front of a magistrate and require a judge. So if you end up in front of a magistrate and you don't like how things are going, you can turn to your attorney and say, I think I'd rather have a judge rather than a magistrate. Magistrates cannot conduct jury trials, but in covenant cases, that's not an issue. We really don't want a jury trial, so that doesn't become a big deal. But there are many, many magistrates, and a lot more than there ever used to be. It used to be magistrates were far and few between, but the courts are so busy, we're seeing a lot more magistrates, and that becomes important when you're trying to figure out, when you evaluate a case, you want to evaluate not only where to file the case. Do we file it in small claims? Do we file it in county court? Do we file it in district court? You want to consider, is it going to be in front of a judge or a magistrate? Because sometimes that makes a big difference. Judges are appointed through a system where they're interviewed by a nominating committee in each different county, and then they're appointed by the judge or by the governor of the state of Colorado. So that makes a difference because it takes time to get through that process, and you end up with judges whose preferences mirror the governor. So for a while, we had a governor who was an ex-prosecutor. He put a lot of prosecutors on the bench. After he left, we had governors who wanted defense attorneys on the bench, and that's what he's done. He's put a whole bunch of defense attorneys on the bench. In Colorado, across the state, there are over 400 judges and magistrates, okay? Since 2011, 178 of the 354 judges are new to the bench. So what's that mean? We got a lot of inexperienced judges out there. That's what that means. And that means that you as a manager, you as a board member, whoever you are, when you're taking the stand, when they're new, you can't just say, well, you know, under Kiowa, because they're going to say, what is Kiowa? They don't know what that is. They may have practice. If you have a court case and your court case is in front of a prosecutor, they've never heard of Kiowa. They didn't deal with it. They know the criminal laws. So you need to know that because you have a lot of new judges out there, you're going to have to do a lot of educating when you're a witness, and you need to be ready to tell the story. Taking the stand and saying yes and no to questions asked by the lawyer doesn't help your case. Like you need to be the one talking to the judge. You need to be explaining to the judge what you do for a living, how you do it, where you do it, why the judge can trust you, why your experience, what your background is. That helps the judge develop kind of a rapport with you, helps him judge your credibility. And when you have new judges, they need a lot more information than an older judge would have needed. The other issue that you run into when you have new judges is they don't have a lot of control in their courtroom. What we see is new judges are much less likely to shut down somebody who's talking even though it's not their turn. So if you have a homeowner who has been belligerent nonstop to the board and we're going to go in court, we're going to hope like heck that we get a judge who's been on the bench long enough to shut them down. Because if you get an old judge, they've been around long enough, they understand what's going on. And that older judge, that senior judge, they're going to have no problem politely telling your rambunctious homeowner who is now a defendant that they need to sit down. It's not. But if you get a new judge, when that homeowner talks back, that new judge will let them. And you will have a trial that takes a very, very long time because that new judge doesn't have the ability to control the courtroom, doesn't have the ability to politely and efficiently shut down that homeowner who just keeps talking and talking and talking over the judge and talking over the other side. So that becomes difficult. Pro se's, meaning without an attorney, you're in the courtroom by yourself, more and more prevalent in the courtroom, and that delays the courtroom proceedings. So if you have a courtroom, even if you're just going there for a pretrial conference, your case might be set at 9 o'clock on the docket. If there are 20 cases and they're all 20 cases with attorneys, each case may take 5 to 10 minutes. Court gets the information, does whatever setting is needed, and you move right along. And the case is very prompt, very quick. If you have 20 cases with 20 pro ses, you are going to be sitting there for several hours because, again, the pro ses don't know what's happening in court. They don't understand what's going on. And so instead of the judge being able to efficiently move through the docket and call one case after another, do the work and move on, he has to stop and educate every pro se all the way through the case. And so the more and more we see pro ses, the longer the court cases go. And again, if it's a new judge, like we're seeing, they don't have control of the courtroom, and so it takes that much longer. So how does that help? How does that information help us? Well, as attorneys, we have to evaluate a lawsuit. How do we start that? We obviously look to the law, Kiowa for the most part, or the Nonprofit Act. And then we start looking at the governing documents. Obviously, sometimes we're going to look at some federal law, maybe issues involving Fair Housing Act, or maybe involving FCC because it's got to do with the satellite dish. And we're going to evaluate. Can we show that, in fact, we have witnesses and photos to demonstrate that the homeowner violated the declaration or violated the rules? And can we show that the declaration and or the rules are in compliance with the law? That's your normal process to evaluate a lawsuit. Obviously, sometimes we have to throw in there some experts. Maybe we're arguing whether or not a contract was properly some work done for the association was properly installed. We might need an engineer to come testify. We have to evaluate whether or not the defendant is operating on emotions. Are they fighting you because emotionally they want this house to be the same color their mother's house was when their mother passed away, and they're only operating on emotion. They're not operating on the rules and the rules that state only certain paint colors are allowed. We have to evaluate what's going to happen in front of the judge, who's going to hear the case. If it's a covenant case, it's going in front of a judge. If it's not a covenant case, it's going to go to a jury. So now let's go back. What did I just tell you? We have a lot of new judges. So now we have to mix that in. Okay, can I persuade a new judge who wants to help the pro se homeowner and wants to hold their hand all the way through the trial? Can I still persuade them that I have enough evidence and facts that in fact show that this homeowner violated the covenants? So there's a lot more dotting the I's, crossing the T's, and a lot more proof to a court that the HOA wore the white hat the whole time, right? Not just, yes, the covenants require you get pre-approval before you paint, but how many letters did you send that homeowner trying to explain to the homeowner? How many times did you invite the homeowner to come talk to the board, to come talk to the Architectural Control Committee? We have to, when we're talking new judges, step back from our evaluation of the lawsuit and say, wow, can we really make sure that we can persuade this new judge who really wants to be the nice guy, that in fact, we were in the right, that we did everything possible before going into a courtroom. We did everything possible before we filed a lawsuit. So when you're talking new judges, you might want to have a couple more letters that go out before you turn it over to the lawyer, just because you've got a lot of pro ses and the judges are going to kind of want them to want to feel that they're being fair to both sides. And sometimes it's really hard for a judge to explain to a homeowner, I know you really wanted this color, it's just not allowed. One of the questions or comments was, if a judge cannot control the courtroom, he should not be a judge. Well, unfortunately, a lot of lawyers have a lot of skills and a lot of expertise. It just takes them some time to settle in. And most of them do it after a bit, but not right away. As part of educating a new judge, can you ask the judge to require a time limit that each person can speak, or ask that others cannot interrupt? Judges know that pro se should not interrupt. Telling a judge, if I'm the plaintiff and I'm going to walk in front of the courtroom and I know the judge is new, I'm not going to tell the judge how to do his job. That's not going to get me brownie points. That's not going to make the judge like me if I start telling the judge how to do his job. It does not help us. It's one of those things that, oftentimes we have clients, our board members, did we get an answer? Did we get an answer? Has the judge ruled? And we have to remember that if I pester the court and I constantly am calling the court clerk and calling the judge going, have you ruled? Have you ruled? Have you ruled? It's going to annoy him. And he's the one I want to like me and rule in my favor. So it's a very fine line that I have to walk. Yes, we can follow up with the judge, make sure our motion got in front of the judge, but we do not want to pester them because, again, don't want to tick off the person who's going to rule for or against me. And the other thing that you need to remember is when we have new judges, the lawsuits get more timely, meaning it takes more time in court because we have to sit through all the pro ses. The court might want to have multiple hearings trying to answer all the pro ses questions and trying to walk the pro ses through the case. Because of that, that means that we're going to have more invested as far as more attorney's fees. These new judges may never have dealt with attorney's fees, and so that's something that they're going to, we're going to have to educate them on that too. And that may mean that the HOA is going to have to hire a lawyer to come testify as an expert at the end of the hearing, at the end of the trial, to explain to the judge, here's what a standard attorney fee hourly rate is. Your plaintiff's counsel is within that normal range. Therefore, the fees are appropriate and the court should award it. So it's an extra expense up front to help prove your case because, again, we're educating judges because we have so many new ones on the bench. So we always want to make sure that we are ready and we understand when we're talking to our clients, to the board members, that the considerations in front of the judge are a little different when we have new judges. And we want to make sure that we're kind of evaluating the cost. What's it going to cost to get through court? And it's going to be a little more. And so we want to make sure that we're able to analyze the case all together so everybody's on the same page. Because of that, again, it's a little more difficult. It's a little more involved. We got a little more things that we have to take care of and make sure we're all on the same page when we're talking to our board members. Remember, when we have gone through this before, you've probably heard this before if you've ever worked with me on a file or a lawsuit. When the lawsuit is filed, each side is required to provide the other side discovery or disclosures. If nothing is provided, then the rules, the court rules, prohibit introduction into court. Okay, now that's the law, but now we've got new judges and we have a lot of pro ses. You can go online and kind of research, but the pro se numbers are going up and up. And when you talk to the judges will tell you that they're getting instructions on how they're supposed to help the pro ses get their case through court. So they're going to bend over backwards and they're going to try to bend the rules. And it is not uncommon for them to allow in things that shouldn't come in. So when you evaluated the case and you looked at the facts and you said, yes, we have all the documentation we need to prove our case, then you need to sit back and think, what is it the defendant has been telling you, what the homeowner's been telling you if they're talking to you and fighting with you? Because we need to know what that is. Because there may be a good chance that the homeowner, even though they're supposed to send the attorney, me, all their documents, they may not. They may just bring them to court. And then they're going to say, well, I'm not a lawyer. I didn't know, judge. And then we'll have to wait and see whether or not the court makes them follow the law or just lets them bring in all the evidence. So as a manager, if you are getting documents from a homeowner, not only do you need to pull your documents that you gave the homeowner and send that to the attorney before the trial, you need to pull everything you can find that the homeowner gave you and send that to the attorney, because both of those need to be evaluated, because the attorney, I should get a copy from the defendant, but because he's pro se, I may not. And so if you've got it, please provide it, because with judges that are new, they're trying to be fair to the pro ses, and that means they let them get away with things like not providing their disclosures. Again, because we're talking new judges, we need to make sure that we are being much, much more thorough in our evaluation. We need all of these documents. We need them in a legible format. And nowadays, that becomes even more important because we may be presenting this information online. That means that I have to make sure that the documents that I am going to provide to the court can be read on a screen, and that they can be pulled up in a PDF and they're still legible. That means if you've got a copy of a declaration for your community and it's been copied 14 times and it's got dots and just scatter and it's not a clear looking document, we're going to have some problems in court. So we may need to go pull new documents from the clerk and recorder. We may need to pull better documents and clean things up, because we need to make sure that the documents we have can be provided on computer, can be seen and read clearly on computer. Same with resolutions and correspondence. If you've got that homeowner who sends you something which is scribbles all over a document, you want to make sure that you photocopy both the front and the back. You need to make sure that when you make copies of a document, we can tell if there are different stages. For example, let's look at think of an architectural request form. It's submitted by the homeowner. That's one sheet. If your architectural committee then writes on that, that should be a second copy. So we need to have it in its original state, just as submitted by the homeowner. Then we need to have the copy where the architectural committee wrote notes on it. Because when we start presenting that in front of the judge as copies, sometimes those copies aren't in color. And if they're not in color, the court can't see what was the original document of the owner. Because it's different than handing the judge something and he can see, because he's got the document and he can see how it's in different colors, maybe different color inks. When you start doing copies, if your copies or your scans were in color, it's not going to show to the court what was original, what was added, what are the different layers. What if, in fact, you had an email string that went back and forth and people had different colors, but when you scanned it, it came out as black and white. The court can't track that. And so when we're doing things and we're doing it in email, we need to be very careful how we're scanning them, how we're using them to make sure that we are keeping it so that just though we might be online, we haven't lost information we want to give to the court. Meeting minutes. Meeting minutes, again, are something that becomes important if your homeowner has come forward, has said something in the meeting minutes. A lot of times you might have manager changes or you might have board member changes between the trial and when things happen at meetings. So we may have multiple witnesses. And if we can't find those witnesses, hopefully the meeting minutes are going to help us. But again, we've got to dig through that, because one of the things, as I said, with a new judge, we're going to have to be bending over to show the judge, look, we had a meeting with him. This was the discussion at the meeting. This is what happened. I'm going to be able to show the court everything. Covenant violation logs. This is not something necessarily new, but is something we're seeing that's being requested, and the courts want to see this kind of thing. They want to know that there are other homeowners being treated the same, because every homeowner who goes in front of the judge thinks that they are the only homeowner who is having something like this happen to them, that they are the only person that is being affected like this. And so they need to see, the judges, especially new judges, that other homeowners also got these violation letters, but the other homeowners fixed it, and this defendant didn't. Photos are critical, guys. This continues. You've got to have photos showing before, after. If you have a claim that a homeowner is not maintaining the property, you need to have photos not just of the violation, but of the surrounding neighbors that show that they are maintaining and your homeowner who you have in court is not. What's the comparison? Remember, we're educating a judge. We're explaining to the judge why this one homeowner is in violation. And we want to make sure that we get all of these things in front of the judge. The other thing we're seeing is, again, A lot of people are texting. They're texting back and forth. They're texting the manager. They're texting the board members. We need to be able to show to the court these text messages. So it becomes important that you as board members or you as managers have an ability to get that text message into a format that we can show the court. And that does not mean it's on your phone. It means a format that we can print, get into a PDF, scan to the courtroom. It becomes very important that we have that ability to show these messages. Again, every bit of communication that we can show to the court to prove to the court how often we have tried to work with this homeowner puts us that much in a better position, because again, these new judges want to make sure everything is fair. And if we show, yes, judge, these are all the letters we've sent, these are all the attempts we've made, we've tried to communicate by phone, we've tried to communicate by text, we've tried to communicate by letter, everything you can show the judge, that's going to help you in court. Remember that part of the issues that we have to show a courtroom in Colorado right now is that there is a collection policy and there is a covenant policy. And I need a signed copy. And I can't tell you the number of files where even on your websites, the policy that's there might be the adopted policy, but it's not signed. So make sure when you're looking at all of your documents and getting ready to go to court, we have signed policies. We need every letter sent to the good, bad, and indifferent, and every response the owner sent back, all the complaints by anyone, all the photos, any application, any denial, any approval, minutes from meetings, emails, texts, ledgers, all of those things become critical. If meeting minutes need to be short and capture just a brief description, especially information that may lead to a motion, what's a good rule of thumb so that you capture information that may be needed for a court case? If you have a home owner who is there for a hearing, you want to make sure that you, the manager, have taken notes. They don't need to be in the minutes necessarily, but they need to be in notes, and they need to be in notes that the next manager can look at. And if the homeowner has given you any documents, your meeting minutes would say, homeowner appeared, spoke to the board kept documents given if they were provided, so that we know from looking at your meeting minutes that are short, right, that the homeowner appeared, that he gave you documents. Now we know to go back to his file and start looking for those documents. I do not want you, and I do not expect you to make meeting minutes transcripts. So your comment is absolutely correct. They need to be short and brief, but they need to lead you, the manager, to the information so that when you go to court, you're ready to testify. Okay, so if the homeowner brought witnesses, write down the witnesses' names. That should be part of the minutes. Again, we need to know enough that 6 months down the road, we can go look at those minutes and go, okay, I remember now. He brought the neighbor who claimed that this has always been that way, or everybody in the community does this. You need to have enough that you can refresh your memory. And more importantly, managers change. They change communities. You may not be around anymore. I may need to take your meeting minutes and refresh a board member's recollection with them. So I need enough in there that I can refresh the memory of what came up during that meeting, and somebody else can testify to it. Introducing evidence in court. Okay, so the old procedure was you mail the discovery to opposing party, and then you bring that physical document to court. Well, now, again, some of these hearings are virtual. So I not only have to have the documents, I have to file them in advance with, which means the homeowner also gets them in advance. And everybody can see what these documents look like. So it's important, and things have to happen that much more timely. They cannot be last minute, because I can't last minute upload things to the court, because once I've uploaded it, it then has to be accepted by the court, approved by the court, and then it goes over to the judge. So if I do it the morning of trial, it's too late. The judge can't pull it up. So because how we present cases now, with some of them being virtual and some of them being in person, the process is more difficult, and it just requires all of us to be ready sooner. For a violation that goes to legal, are legal fees chargeable to the homeowners? That depends. Don't you love it? It's a lawyer answer. If in fact your community is a community that is a Kiowa community, Kiowa states at section 123 that the attorney's fees, even pre-litigation, meaning so you've sent the violation to the attorney sent out a letter, even that's pre-litigation, those fees may be chargeable to the homeowner. But once you file the lawsuit, Kiowa says that at that point, the fees are recoverable once awarded by the court. So if you send out a demand letter, you can put those fees right on his ledger. But then if you have to file the lawsuit, you have to hold those fees until the end of trial. And when you win, then you present them to the court and you get a court order, and then those can go on the ledger. So once you file that litigation, they really should not be going on the homeowner's account because of the wording of the statute. Now, if you're not a Kiowa community, it'll be completely dependent upon what your declaration says. If you're a metro district, it will be dependent upon whether you're enforcing covenants through an agreement or not, because that's going to determine whether or not Kiowa applies. So lots of different options of whether or not the legal fees can go onto the homeowner. A lot of times they can. So as a witness, when you're getting prepared by your attorney, it becomes more important that you understand not only, what to wear, and what you wear in court should be something that your grandmother would approve of you basically going to church in. Something that's not going to upset anybody. Never have a shirt with words on it. Never have anything that is going to politically show one side or another. Many times in court cases, I've had judges order witnesses in front of a jury to remove a pin that they're wearing because the pin might be one that the judge found to be politically choosing a side over something. So you want to make sure you're not wearing anything like that, because you don't know which side of any kind of agenda you're going to meet when you're in a courtroom. So always wear stuff that's not going to show any political side and that is not going to offend anybody. And then you want to have documents with you that are part of the file and that you've already turned over to the lawyer, okay? When you go up on a witness stand, you cannot take those documents with you, because anything you would walk up to the witness stand with, the other side could demand that you hand over. And so unless you want to hand over your entire file, you're not going to take them up on the witness stand. Bring it to court with you, show it to your attorney, but you're not going to take it. Well, what happens now if it's a virtual hearing? Well, now that's when you really want to talk to your attorney in advance. I find it best, and what I have done on multiple occasions when I've had a virtual hearing is had my witnesses come to the office, so we're still sitting in the same room. We're still side by side. If they have a question, we can ask the court for a recess, and I can talk to them. Sometimes I understand that's impossible and you need to testify from remotely wherever you're at. But if that's the case, then you need to be prepped in advance. How do you log in? What do you do once that you are logged in? When you log into a court case, everyone who's logged in can see you. Depending on the court, if there are a bunch of people logged in, the court might have a big monitor in their courtroom, and everyone in the courtroom can see everybody logged in. So that means don't have someone else in the room with you telling you things. Don't be making faces. Don't be commenting on things even though you think it's under your breath, because depending on how good your mic is, the judge might hear it. Okay. So try and have, if you can, a background that is similar to mine, a wall, maybe a bookshelf. What you don't want is maybe a hallway that somebody else in the house is going to go walking past and distract the judge while you're testifying. Think in advance what can be seen and what can't be seen, because you want to make sure that you're not going to be presenting something other than what you want to present. One of the things many of you may have seen or laughed about, but this is a Zoom call that an attorney had with a judge. And the attorney is the cat down there in the bottom right-hand corner, because he couldn't figure out how to turn off a screen shot that was of a cat. And as I understand it, the way that the screen, how he had it set up, the little cat's mouth would move when he was talking. Okay, not a good image. Know how to work a Zoom call. Know how to make sure that you can turn off any filter that anyone else in your household may have turned on, because you don't want to appear and try and testify as a cat. Remember, when you're testifying, you want to make sure that you remember in advance what's going to happen, what happened in the past, and you want to be able to answer anything that may have come up in the past. So, for example, if you're talking about, let's say the lawsuit is a homeowner who painted their house the wrong color, you need to make sure that you're familiar with where all the documents are for your association. Are they kept on a website? Are they kept in a notebook? Where all does the defendant have access to them? Because those are all questions that your attorney is going to ask you. And you need to be able to answer those questions. You need to know how often have rules been adopted or changed in your community. You need to be ready to talk about the facts and the issues that the homeowner may have already raised with you. If the homeowner has already said, well, there are other houses the same color in the community, you need to be ready to answer those questions. That means that if he's previously said there are 4 other white houses in your community, you need to be ready to say, no, 3 of those are across the street in a different community, and the one that's there was approved 10 years ago when the different rules were in place, or whatever the case may be. You need to be ready to talk about that. That means you have to have read through your notes. You have to have prepped yourself with your attorney in advance. I highly recommend that you sit down and talk to your attorney prior to any case, any hearing, so you can discuss what's come up in the past, what hasn't come up, what's worked, what hasn't worked, gone through all the different things that might pop up during that trial. You don't want to try and have an argument with the defendant. If you know the defendant is going to push your buttons because you know this defendant calls everybody names, take the high road. The judge isn't going to like the actions of a defendant when he cross-examines you if he gets in your face or she gets in your face. But if you rise to her level and go right back at it, you're not going to look it either. So you want to take time to work with your attorney about what's going to happen and what to expect. You need to understand that any document that is presented, if you yourself didn't type it, it's hearsay. So then you need to understand that the attorney knows that there might be hearsay exceptions that allow that document to come into evidence. You're going to have to answer questions about that. Those documents may not be in front of you. This may be a virtual hearing. So you can't thumb through the document. You need to be ready to say, yes, the attorney sent me the documents that are being presented. Yes, I looked through all of them and read through the PDF that she sent me the night before. Yes, I know this is our declaration. This is the same as the paper copy I keep on my desk. Because if you can't say those things, it's not coming into evidence and you're not going to prevail in court. Do not assume just because you've been to court 100 times that you can wing it. You are going to have to work in advance and make sure that you have looked at all the documents in advance, because it becomes much more cumbersome if it's a virtual hearing. You do not want to be the person who sits on the stand and just says yes and no. It's really hard to judge credibility. You want to talk. You're an experienced manager. If the question is, what is this document? And it's the declaration, read off the title's name. This is the Declaration of Covenants, Conditions, and Restrictions for this community. How do you know what it is? Well, I've read it multiple times, because every time a question comes up, I know this is the basis for all of the answers. This is where I go to. Those are the kinds of questions that educates the judge by your job and how you do your job. I know that it's nerve-wracking to be on the bench or to be sitting in the witness chair, even if that witness chair is at your home, the spotlight's still on you, but educate that judge. Explain to them how hard the role of a manager is. Judges, if they don't do a lot of work like this, hear nothing but what the media has to say. And we all know that's not good. You need to educate them on how hard you work and how you work with your homeowners, how you work with your board, how you work your best to keep their property values up. Your job is helping the defendant and every one of his neighbors, because it helps keep their property values up. But you are the person who has to share that information with the judge. And it may not be in person. It may be remote, just like right now. And so even though it's not a conversation that is normal, get used to talking, even though you're talking to a computer screen, because you're still going to have to educate that judge, even if it's remote. So again, at the end of the trial, when you win, now you want to get your attorney's fees. You want to recover those attorney's fees. Prospects for recovering attorney's fees is more difficult with a new judge. There is no doubt about it. If that new judge's background is one that's all criminal law, you may want to talk in advance with your attorney about hiring an expert to come testify in your case. That criminal attorney is not going to know what the standard legal fees are, what standard hourly rates are, and so you want to be ready for that. And you know, there are risks that, you know, the court will come down and say, well, you know, I'm going to cut your fees. I will tell you right now that on average, we see about a 15% cut of attorney's fees. It doesn't, the days of getting all of your attorney's fees when you go to court are long gone. Judges just do not award, if you go all the way through trial, they just do not award all of your attorney's fees. So you need to know that, and your board needs to know that up front. If you do not have fee shifting, you have to follow the American rule. Just so you know, the American rule is a rule of the court that basically says each side pays their own attorney's fees. The only time that changes if the contract or a statute say losing party pays. So if Kiowa applies to your community, it has that's the statute that says losing party pays. If you're not a Kiowa community, then you have to look to the declaration. That's your contract, and make sure that that declaration says losing party pays attorney fees. If you don't have that, you're not going to get attorney's fees for your client. Question, isn't it better to have the secretary of the board take the minutes? They're the ones who live there, so help educate the board on how to take minutes. You know, again, a lot of boards feel that they've contracted with a management company to take the minutes, and they want the manager to take the minutes. That is between the board and the manager contractually as to who takes those minutes. And obviously where they're kept and how detailed they are. That's something that a lot of communities change frequently, depending on who the secretary is, because some secretaries are very detail oriented, and we have to work with them actually to scale back and not create transcripts, but create minutes. But again, trials can take a long time to get in front of a judge. And as I said, with COVID, we're taking longer to get in front of a judge. So you might have new board members when you get to trial. You may not. I mean, generally you can find one who is still there, who was there at the beginning and got all the way through. but you want to make sure that you've got one person who is there for all of it and can talk to the court about what happened and why we're here. So how do we avoid being sued if we're the board? Because again, we're in front of new judges. We don't know whether we're going to get all our attorney's fees. You know, as a board, as a manager, you really need to work with your boards about just being aware of obligations. It's important as managers that you help your boards understand their obligations under the declaration. That you help your board members take the time to go get educated so that they're not going to do something that's going to cause them to be sued, that they're not going to have a conversation that's going to cause them to be sued. The claims and the accusations that we are seeing day in and day out. People, just yesterday, I was working on a case where we filed suit. The suit is about a trailer in a driveway. And lo and behold, out of the blue, never heard this before. Now, all of a sudden, the homeowner claims that the board member, who was his neighbor, was a racist and was making accusations. We've never heard this before, ever. But now this accusation is coming to light because this person is being sued and he doesn't like it and he thinks he's going to lose his case. And so now he's trying to find a way to push back and make a counterclaim. So try and help your board members understand that once they have that board member hat, that all of their actions are going to come under scrutiny and they need to be careful. They need to be careful what they post on Facebook. They need to be careful what they say when they're speaking out in the community. If you have a next door in your community, you want to make sure that you've talked to your board members about what they're posting, what they're saying, what they're not saying. If in fact you look like things are going sideways in a vendor contract, you want to be monitoring the communication between that vendor and your board and make sure nobody's promising, oh, it's okay, we'll give you more time, or we'll do this, or we'll do that, because that may change things, it may change obligations, it may alter contracts. As a manager, your job becomes more difficult, but you need to kind of stop the things that are happening and try and avoid the lawsuits because, again, they're expensive, they're costly, and we have lots of new judges who don't know what's going on. Speaking of owners claiming they're singled out, what do you recommend about owners and weeds? So that's where the logs come in. Back at the beginning slide, I said covenant enforcement logs become really critical and really important. Having that covenant enforcement log that shows I have a community of 200 homes. I sent out weed letters to 50 homes. I drive the community day in, day out. I don't even know who lives in any of these homes. So when I put a manager on the stand, that helps defeat the racial profiling claims, the discrimination claims, and the log shows 50 letters went out. That helps defeat the claim that somebody's being singled out. It just means that they were the only one who didn't fix it when 50 letters went out. Making sure you're looking at your declaration and your policy and you're working with your insurance agents. I know insurance is becoming more and more of an issue, and I know it's more and more expensive. And I know that HOAs are trying to find a way to save costs at any expense. You really need to have them work with an HOA agent who understands insurance because you want to make sure that they're carrying the proper insurance that they need. You need to make sure you have all the policies, they're all signed. Obviously, right now, we might be looking at tweaking a lot of policies with the new bills going through the House. If they become laws, work with your attorney to make sure you're current. You've got to make sure that you are following every policy that you have so that you can't be attacked on those as well. And with or without new judges, you need to remember, judges are human. They may live in HOAs themselves. They may have their own opinion of HOAs. They may never have been around an HOA. They may have never seen an HOA, and all they have is what they see in the media. We need to remember when you go in front of a judge, new or not new, this judge comes at it with his own preconceptions And we need to make sure that we show at all time we acted within the scope of our authority, we acted in good faith, that the covenant is enforceable and is fairly enforced, that we have violation logs showing that we're fairly going after everybody, that we're not singling anybody out. We're still going to have the same old defenses we've always had. We're still going to have the challenges that you didn't adopt the rule right, or you didn't amend your covenants correctly, you didn't follow your own procedures. We have to make sure that we have dotted every I, crossed every T, and walked in there in the white hat. Because if we don't do that, these same challenges that come up every time we walk into a courtroom are still going to get us. We still have to defend against these. We still have to make sure we're following the proper steps. The claims, none of these claims have changed. None of these are getting any more or less easy to defeat with new judges. We still have to go through all of these, make sure that we are aware of the statute of limitations, that we're meeting everything that we have to meet, because this is just, none of this has changed. We're still seeing the same kind of claims that we've always seen. And we're still seeing that even with the new judges and with COVID and with the changes. And so none of that changes. It becomes more difficult. And that is all of the slides that I have. So I have a couple questions here. So what is laches and estoppel? So laches is a situation where you have a homeowner who got a letter because he parked his trailer somewhere he's not allowed to park his trailer. And he said to you, what do you mean I'm in violation? I've been parking that trailer there for 20 years and you've never done anything before. Laches means you did not act on a violation for so many years, it's not fair that you act now. So if you had a prior board that was in place for 10 years and that prior board never wanted to act on any violation, the minute they're off the board, you cannot now all of a sudden change and immediately start enforcing. There has to be a period of time where you send out letters and tell everybody, I know that in the past, the old board didn't take action, but the homeowners have elected a new board because they want these covenants enforced. So we're going to start enforcing them. So you're going to start seeing violation letters if you're in violation of these different issues starting in a month. That will break the laches argument. Estoppel is when a homeowner says, I've been parking that trailer forever, nobody ever cared, and because you guys never did anything, I poured a cement pad right there where that trailer sits. So I did something to my detriment in reliance upon your inaction, and therefore you are estopped from taking action against me. And if he's true that he'd been parking it there for 10 years and nobody ever did anything, and he then did something to his detriment, he spent money based on his reliance of no action, the HOA is stopped from taking action after the fact. So you have to be aware of that. How are the statute of limitations being handled with court delays? It really doesn't affect them because statute of limitations is from the date the violation happens to the date you file the lawsuit. And so you still have the ability to file the lawsuit within the statute of limitations, and so no slack is being given. You still have the same statute of limitations and you really can't change it. You just have to proceed on. Now, your case might drag out a lot longer because the courts are backed up and don't have a lot of time, but the courts aren't doing anything. The issue with the courts is that for the criminal cases, speedy trial is what's making us get bounced out of the courtroom because the courts are delayed, and if those defendants didn't waive their speedy trial rights, they get to go to trial first before us in the civil cases. And so that is being affected by COVID and all the delays. Question, the 12-month rule, does this not count towards items that may have been installed or placed on common area? So if a homeowner places something on common area, that's trespass. And there are cases out there that say trespass is what's called a continuing violation that is a new violation every day it occurs. So you never run out of the statute of limitations because it's trespass. Now, the problem is after 18 years of trespassing, there can be an adverse possession claim of that common element. But that's 18 years, not 1 year. So if they put something on your common area, that does not have the 1 year statute of limitations issue because it's trespass. And that's all of our time. Thank you, everyone. Have a happy Cinco de Mayo. Go have a margarita. Enjoy. Thanks all.